Welcome to Trial Lawyer Review, a podcast for and about trial lawyers. We will tell the stories about trial lawyers who go to battle every day in courtrooms throughout the United States for injury victims. This is about their stories and their practices. Hello everyone, I'm Jason Lazarus, your host for Trial Lawyer Review. Thank you for tuning in today for another episode. Trial Lawyer Review is brought to you by Synergy Settlement Services. In full disclosure, I'm not a professional podcaster. Instead, my day job is Chief Executive Officer of Synergy Settlement Services. Synergy allows trial lawyers to focus on what they do best by handling the difficult issues that arise at settlement, like troublesome lien resolution issues, Medicare secondary payer compliance, government benefit preservation techniques, and complex settlement planning.
Joining me today on Trial Lawyer Review is Ilya Lerma and Jamie Holland. They're both excellent trial lawyers with a specialization in litigating brain injury cases, among catastrophic injury cases and other types of cases. But today's episode is a special one with a discussion focused on litigating brain injury cases. I heard Ilya speak at an FJA, Florida Justice Association seminar, along with Jamie on the topic of handling these cases, and thought it would make a great episode for the Trial Law Review podcast. Since we have a lot to cover today, I'm going to do a brief introduction for both of them, which I'll read. Ilya is an outstanding trial lawyer practicing with her own Phoenix-based law firm, the law offices of Ilya Lerma. Due to medical issues affecting a close family member, she grew up around neurologists, neuropsychologists, and neurosurgeons, and even planned to attend medical school. Over the years, insidious brain injuries and concussions impacted her closest friends and relationships, and early in her practice, she became a voice for clients suffering these injuries. For more than 2 decades, she's unearthed the details of her clients' cases because she knew and understood where to look. She uncovered the evidence so that she could not only deliver the stories of their injuries, but their lives. And Jamie's a phenomenally accomplished trial lawyer, bringing nearly 3 decades of trial experience to Holland law firm. He's a board certified trial attorney who takes a compassionate approach to his cases. His goal is to help clients make the best of difficult situations and serve as their trusted legal advocate during and after their cases. When he's not representing clients, he can be found coaching trial advocates and teaching CLEs. Holland's exemplary work and dedication to ensuring justice for his clients has landed him multiple accolades and recognition. Welcome, Ilya and Jamie, to Trial Lawyer Review. So glad that you guys could both join me today for what should be a very interesting discussion about these types of cases.
Thanks, Jason.
So before we jump into talking about the brain injury cases, I wanted to ask you both about trial structure, since you both are instructors. What is it and what has it done for your practices, as well as what does it do to help other trial lawyers?
Wow, that's a big question. I'll give a summary and state that trial structure is really a method of breaking down cases and rearranging the pieces for the most powerful and compelling persuasion effort at trial. We all know that people learn in different ways, and sometimes processing information is really difficult, getting the message across. And so trial structure really teaches trial lawyers, plaintiffs only, how to rearrange the pieces of their case for the best trial presentation possible. And what's great about it and how it helps attorneys is it's a method that can be reapplied in every single case, so that you learn it, you practice it, you master it, so that ultimately spotting patterns, predicting outcomes, predicting defenses becomes integral to case development, and trial structure teaches you how to do that.
I'll just add to that. If I had to put it in a sentence, it's how to put the juice in the jury box. I mean, that's what it does.
And did you guys actually meet through trial structure, or were you acquainted before you both became instructors at trial structure?
We met through it. I was, candidly, I learned a little bit, more than a little bit. I learned a lot from Ilya, and became an instructor myself. And we have shared and mentored each other along the way. I think candidly, I've probably gotten a lot more than I've given, but I'll take what I can get. So,
He says that that's not at all true. But we sort of met through the school in terms of becoming instructors for trial structure, and we've become friends and colleagues and co-counsel. Pretty much several steps in there along the way.
And one of the beautiful things I see about the plaintiff's bar is their willingness to help each other. And it sounds to me a lot, and I've not been through trial structure, so I can't answer that, but it's just another way of making sure that we all are doing our best job for the people that we serve, which are people that need our help. We do a little bit different. We're at the end of the case, but everything that we do is focused on that. And I really love seeing that same care about serving that population, people that have had their lives disrupted due to these serious injuries. I was going to ask just if you guys have specific examples of how trial structure helps a trial lawyer, as case examples.
Dozens. Dozens. I will say just preliminarily, and then I'll kind of punt to Jamie. I'll say that preliminarily, I think we help plaintiff lawyers because we train them in the methods so that they can ultimately handle these cases on their own. And I think that's one of the things that sets trial structure apart. Not that we don't enjoy co-counseling, not that we won't co-counsel and have been invited many times to co-counsel. In fact, right now I'm in Chicago because of a trial structure case. But really the method is designed to help plaintiff lawyers because we know how difficult it is to go into court right now and ask for, sometimes these 7-figure, 8-figure verdicts or even, 6-figure verdicts or less on a difficult rear-ender case. It's tough. And one of the things I really love about trial structure is it's really developed so that the trial lawyer themselves can hone their skills. They may not try the case by themselves, but they will get better in the method and learn how to develop the case after that.
Yeah, I don't think I've ever had a co-counseling or a coaching relationship where we all didn't leave that day a lot better off. And I'll give you an example. I've got a case that I'm trying. Well, we'll see. I may be trying next month. And I saw it tried the first time. I happened to be in a courtroom next door. I watched it being tried. And these cases, regardless of the case, it's really easy to get in your lawyer head. And it's really easy to get in your lawyer head and to miss the nuances. And part of what trial structure does is it boils it down into the best crystals to give to the jury. And by that process, you end up with a better lawyer, a better case, and a better result instead of trying to struggle with all of these little logic loops that we tend to get caught up in because we tend to be very smart lawyers. But that doesn't make it a very good advocacy. So,
that's actually an interesting point. Thinking along the lines of a case example, Jason, I structured a case. This was with Alejandro. It was actually 17 full days of structuring. It was one of the most difficult battles we'd had because the judge had effectively left only one claim on the table. And it was a case that involved a canine attack. And it was a trained police canine, the purchasing officer of the retired canine who was ultimately turned loose and mauled to death an elderly gentleman and gave a brain injury to his neighbor. The police officer who had adopted the dog was himself a canine trainer. So it was a good case until that last bit of information. And that made it really, really difficult to structure because the failure to warn was sort of assumed by the police department who said, absolutely not. This guy was a trained police officer, so he knew the dangers of not following the training. And after structuring that case, we were able to uncover a story that exposed the fact that the police department knew that adopting this relatively young canine, very young to be retired, to a young officer who had limited police experience, even though he had some training with canines. The police department really knew that the officers had a habit of treating these canines like pets, and they knew that assuming that that this officer would just know that the dog's training could deploy, it just completely changed the case, and that ended up being a $20 million verdict.
I wanted to key in on that term that you guys are using because just to make sure that those who listen really understand it. When you talk about structuring a case, is that the development of a plan, or are you talking about exactly how the case is presented? What does that entail? Not asking you to give away all the secrets, obviously.
You could give us 3 months and we wouldn't be able to reveal all of the secrets because it's pretty in depth, but I'll let Jamie jump in here.
I think I would check box D, all of the above, because it is the approach to the case, how you develop it through discovery and depositions. It is the advocacy of the case, how you develop the best way to present it to a jury so it sticks and isn't just forgotten after 24 hours. And also, I was laughing inside as I listened to Ilya present the canine case, is because literally she's so immersed in trial structure. When she describes something, she's describing it in the method that we teach. And it's part of why it's so powerful, but she's also behind the scenes developing it in that method, training the witnesses so they can deliver it with that empathetic tone that is needed to get everybody on board. So it literally is all of the above.
You really have to understand that there's an emotional core to every story that's being told, and we're hardwired for story. That's what modern trial practice has taught us more than anything. And jurors are really listening and paying close attention and getting the lawyer to understand that they're not just a deliverer of information, but they are a conveyor of a tale. And not in a cinematic Hollywood kind of way. I know there's a lot of trial schools that teach that. I don't. I'm not that good of an actress. But understanding that is really central to developing how the case is ultimately going to be presented.
It's funny, that really resonates with me because I use the facts of what happened to me when I was struck by a car when I was cycling. With everybody that joins our team, I tell them the story of what I went through so that they understand and have a better, realization of who they have the opportunity to help and serve. So, and I think you got to be able to tell that, in a way that resonates with people, in a way that they can connect to it with compassion and hopefully empathy. So interesting because also, one of the things that you were talking about, Jamie, was the witness preparation. And Ilya, when you presented for the FJA seminar that I attended, there was a lot of focus on the witness prep, and I'm wondering how does that fit into the evolution of a personal injury case and making sure that those witnesses are able to do what's necessary to prevail.
Before she speaks, can I do a shameless plug here? And here's the shameless plug. It's for Ilya. I have hired a variety of people to prep my witnesses, including some of the quote top experts. People that make $10,000-$20,000 per prep. And I will tell you this: there's one among them that I currently use and have used for years. And I think I'm pretty good at it, but there is one witness whisperer, and that's Ilya, because she is the best of the best that I found, and has some of the most. Listen, she took a client that was really unable to, because they in the middle of the trial they caved in, went back into PTSD mode. I'm not sharing anything. And responded on a 1 hour notice, got on a Zoom call, spent the next 6 hours with him, breaking down the fences to get him to open up again. And this is somebody I'd already spent hours and days getting ready to take to trial. And she did what was done in days, literally got it back to where it needed to be in just 6 hours. But I hats off to her talent.
Jamie, that was very gracious of you. To answer your question, Jason, I would say it's everything because I know as a young lawyer, my very first big civil trial, we prevailed against the state of Arizona on a gross negligence standard, and the jury's award was it was paltry because they never really connected to my client's story. And I learned then that you can have all the best evidence in the world, but if a jury is not motivated to help your client, if they see no connection to them, they won't do it. And I learned that the hard way. And I've been very fortunate to have some excellent training and good exposure to things that help me reach into people's lives and evolve that. But as plaintiff lawyers, it's awful that we wait till the days leading up to trial. I can't tell you how many times I get called in. Well, we're starting trial on Monday. I've got 3 days to prep this witness who has, TBI and schizophrenia and PTSD and, all these underlying conditions. And unfortunately, they save I think the most important thing for last, because a lot of these witnesses could do like a fantastic job delivering the story if they just had an opportunity to get their agenda out of the way, work out some of the emotional things they need to work out, and then understand the role that they play in the trial.
That's great advice. So I wanted to spend some time talking to you guys about brain injury cases. For me, it's got a little bit of a personal interest since I know that my brain was certainly injured to some extent after getting struck by that car in my face and head striking that car. In my case, there really was no focus on that aspect of the injury, even though I had a concussion and lost, a week of my life before being struck, just because all of my facial injuries and limited coverage, it didn't really matter. But I'm curious about both of your views on the evolution towards the better workup of brain injuries, because I know it used to be very difficult, but science has now evolved to have better diagnostics for mild to moderate TBIs.
We've got a lot better tools to deal with it. I mean, I look back to the first traumatic brain injury case I tried 25 years ago, and we were dealing with a rudimentary SPECT scan. And when I say rudimentary, I mean rudimentary. It looked like a kid playing with a paintbrush in terms of what you could see. And neuropsych, which is neuropsychologists are, well, I'll be as kind as I can. It is a gray science, and they're now circling the wagons defending their practice rather than really, trying to promote it up to the same level the rest of the science has developed to. And so it's not nearly as useful as it was 25 years ago. And in large part, it's been overcome by the defense and insurance industry. And in my opinion, a little bit corrupted. So having the modern tools, the 3T MRI, having the DTI, some added analysis like a neuroquant, having much better, balance testing, much better vision testing, much better tools, and as well as a very important other issue, which is having the biomechanical engineer to defend against the defense biomechanical engineer who's going to come in and say, there was never enough force to cause any injury. And I'll just use your case. They would hire it in your case, Jason, where you had facial fractures to say, well, this doesn't meet the HIC criteria, therefore you must not be injured. Well, come on. But there are some on the jury that will buy into that if you're not prepared to defend against it. And we have the tools to do it now. 25 years ago, we were largely tilting at windmills trying to do that same thing. We were going with the Glasgow Coma Scale, which is about the most useless instrument for predicting outcomes of brain injuries as anything. It's really good for saying, okay, what do we do with the triage in the initial phase? But trying to do long-term predictions over Glasgow Coma Scale, I think you do a better job reading tea leaves.
And that's interesting because I agree with everything that Jamie said. I mean, I think our tools now, the science has really come a long way. It's still way too far behind for where it should be, but it has come a long way from my first concussion case, which was I think about 18 years ago. But I will say the evolution of plaintiff lawyers who are doing TBI, their knowledge base, I think, is also growing. More plaintiff lawyers are aware that they should have some kind of concussion screening for car crash cases, slip and falls. And so I see an evolution there. What I see, though, and I'd be interested in Jamie's thoughts on this, is the medicine is becoming slightly more complicated. If you've got a case where there's a significant value, it's not enough to just go through the checklist and, oh, okay, I've got a DTI and I've got a good neuroradiologist. Like, you really have to be prepared to take an in-depth deposition of a neuroradiologist because the insurance companies are defending these vigorously, and they are hiring experts, neuroradiologists, neurologists to defend at what I would say are unprecedented levels. So I very frequently caution lawyers about assuming that just because you followed the checklist of things that should be done doesn't mean that you're going to be able to get max value. So I very often, especially with younger lawyers, encourage them to co-counsel with somebody who does this on a regular basis or who understands the medicine, because it's sort of jaw-dropping the degree to which I feel like I have to know brain injury medicine going into a deposition.
Very much so, and I will tell you, the minefields are out there and they are thick. And if you leave one single gap in a brain injury case, and I'll use an example, wasn't my personal case, but it was tried down in Tampa. The lawyer who tried it came to me and said, "What do I need?" I told him what he needed, and he opted for making the business decision on a TBI case. He opted not to fill that gap, and it was a biomechanical engineer gap. And had he filled it, I mean, he had a very savvy client. His client was a PhD psychologist, so she knew the medicine. But with that one gap, there drove the entire case, and it was unsuccessful because they left that one gap. And so it's not only a matter of knowing the medicine, knowing the science, it's having the experience to forecast, if we don't do this, this is going to happen, and it's going to happen to my client's detriment. And so it's a combination of it all, and it's not, a simple brain injury case is a complex piece of litigation.
There's no such thing. Those are really good points, Jamie. I agree with all of that.
Well, that's some incredible knowledge and wisdom for trial lawyers who are handling these types of cases. It sounds like it's almost a bit like med mal litigation, where you have a lot of expert intensive depositions that could very well determine the outcome. And if you miss something there, or you miss having the right expert on your side, that it could be very detrimental to the success of your case. I couldn't
put it better. Yeah, absolutely.
I read an article, Ilya, that you co-authored that talked about how brain injuries are insidious and how that plays into litigating cases where symptoms, the onset can be delayed or there's a late diagnosis. Can you guys talk about how that's kind of evolved today with those sorts of situations?
Well, I think as I said, lawyers are a little bit better. We still have a population that's transitioning more slowly than the rest of us, but who are beginning to recognize that very frequently you can have a TBI or a mild traumatic brain injury also from rear end car crashes and slip and falls. And so I do see that there's an evolution because there's a dialogue, right? There's a lot of chatter, a lot of CLEs being put on, so awareness is still there. But I think the problem is that, as Jamie said, forecasting how these claims are going to be fought is part of developing the right plan. And brain injury is not the place where you want to skimp on experts. It's not where you want to skimp on treatment. These are lifetime injuries. And I've had colleagues who said, oh, settle my client's TBI for MTBI for $50,000, and my heart is broken because I've lived with people who have brain injuries. My relative is on my website, and it just and very special people to me. One of my best friends that I met in law school. These are people who their lives were impacted forever, and the thought of settling a case for 50,000, as it's like this affects you the rest of your life. It's heartbreaking. So I think the answer is pretty complex. I could probably talk about that for 2 or 3 hours. But yeah, it's really hard to watch. And while I love the enthusiasm that people have getting into brain injury, it's really something that unless you're going to commit yourself, you shouldn't.
And the analogy to medical malpractice is probably a pretty good one because, I have done some medical malpractice cases in multiple states, but if it looks like a complex medical malpractice case, I am not doing my client a favor by trying to go forward with it. I'm doing my client a favor by getting it in the right hands.
So since you can't see a brain injury outwardly, what are the challenges in bringing that to the jury so the jury understands it?
Well, let me back up a little bit before we get to the jury, and I'll tell you one of the biggest challenges with dealing with brain injured clients. If you want to know whether there's a brain injured client in your client base, ask your staff who the biggest problem child is, and then drill down further and find out why. Many times out of 10, you're going to find out that's a brain injury you didn't know was there. But your staff knows it because they're unpredictable, they don't make appointments, they're late, they're inconsistent. On paper, they're some of the most unattractive people in the world. And I don't mean that meanly. That's how they come across. And there's no explanation for it until you get into the brain injury and you start to find that's the reason for it. And so you then have to understand them, and then you have to present it to a jury. And until you get the medicine out in front of the client, in other words, the client doesn't testify until the jury understands the medicine that causes them to be the way they are. If you try putting the client out first and backfilling it with the medicine, good luck, because the jury doesn't like them already. The jury, they've already been proven to be inconsistent, aka a liar. They've proven to be unpredictable, aka they might come at me. I mean, all of those things that we identify with, quote, bad behavior, I have yet to find a brain injury client who didn't have most, if not all of them. And I've seen people go from being the most wonderful, devoted husbands and fathers in the world to sons having to drag them off of their mothers because they lost their temper and were beating them because they had a frontal brain injury and no impulse control. And if a jury doesn't understand that, you don't have a chance. I mean, I wish I could sugarcoat it, but that's the way it is.
It's really true. And lawyers, I think, even forget about their own client. I'll get calls on these really difficult clients, and gosh, please help this woman. She's driving me nuts. She won't follow directions. Well, they forget that they're brain injured, and their brains don't process information the same way. So I'll come in and I'll tell everybody, put the prior deposition testimony away. Let's not make your client try to remember all the facts and figures because their process is no longer the same, and they feel frustrated on the inside because they know they used to be a CPA before, or they used to, math whiz, and now they can't remember even the date of their injury. And they get frustrated. And that tension between the lawyer and the client, if you go into trial with that, no, the jury's going to see that. You want to make sure that you have, as the trial lawyer, a very good understanding of what it's like to live with a brain injury, and what your client is up against. And then, as Jamie said, you have to lay out the medicine right up front before a jury ever gets an opportunity to see the client. You have to have experts say, look, this person has no, executive functioning ability anymore, or they're functioning at this level, and here's why, and this is what that's going to look like. So when they testify later in the trial, the jury doesn't see, somebody who's maybe unintelligent. They think, oh, well, that's part of the brain injury, right? It's been laid out for them. So everything Jamie said, I would back that up 100%.
And I will tell you, Jason, to go to what you do, which is really good lien resolution and resolution at the back end of a settlement. If you want to have a challenge with a brain injury client, try to explain to them the details of lien resolution and all of the details of what you do. It's almost impossible because they don't have the processing to deal with it. So sometimes you've got to actually get a ward of the court. You got to make them a ward of the court to let somebody else handle that, because it's just very, very difficult. And even those who are some of the better functioning of my brain injury clients, we have to have 5, 6, 7, 8, 9, 10 sit downs to do what you do with somebody else in 20 minutes.
Yeah, I've experienced that firsthand over the last 23 years of working on these types of cases. So I have a question, and maybe you've already answered this, but how do you take a TBI and turn it into translatable evidence that ultimately results in a great recovery for your client? Because we know the defense is minimizing the claim, saying there's really no brain injury. So how do you use evidence to combat those defenses?
Ilya, you want to take the lead with that one, and I'll do the follow on that. I feel like
no,
charging out.
I think we both have things to add. I would say that evidence in a TBI case is very layered, right? You have the imaging, and then you have other clinicians talk about, neurologists. We use a biomedicine specialist very often to corroborate the injury, right? So you can talk about the biomechanics of the injury, or the biomedicine of the injury, how the body moves, how the brain gets damaged, what structures are ruptured. And so you can use imaging, also visual demonstrations to show how the brain shifts within the skull. And then you have neuroradiologists to be able to talk about the findings on imaging. You have neurologists to talk about how functioning. You may have a neuropsychologist, if you've got a strong one. There's a myriad of ways to layer that, but really ultimately what you do is you show that the injury, the mechanism of injury, the certain part of the brain that was affected shows up on imaging. It's the same part that is demonstrating lack of function, and that coordination helps to corroborate the injury. And then you get family and friends, before and after witnesses, to be able to talk about what they were like before, how they're now different, and does that line up also with the part of the brain. For instance, my family member has a left temporal lobe issue, and so a lot of his, he lines up perfectly with a left temporal lobe disorder, predictably. So having people who are familiar with what part of the brain is affected and how that manifests and what it looks like every day, then the jury starts to hear things from family members, and they go, oh yeah, that's right. The neuropsychologist said that was going to affect short-term memory. And so they line those things up, and they really like to, be able to put those pieces together. So your job is to lay it out for them so that they can connect the dots.
I agree completely with what Ilya said, with a few additions. If you are not anchoring your brain injury in objectives, in other words, if you're not, putting down concrete markers down in that soft sand to make it as anchored as you can, you're going to get drug off that beach, and your client's going to get drug right with you. And so you've got to hit every, you got to hit the balance, you got to hit the vision, you got to hit the MRI DTI. And then once you get all that, you not only have to backstop it with the before and after witnesses, but you better be able to visualize it. You better be able to take the MRI DTI or take the MRI and volumize it and have a graphic image done of it so that they can see exactly where the injury is. Because if I say prefrontal cortex, everybody goes, oh, you've got to peel back the layers of the brain to show exactly how it matches up, how that matches up with the biomechanics, how the occupant moved within the car when they hit their head on the windshield. All of that has got to be a complete picture. And if it's not, it's going to be a bad day.
So this next question may take us full circle back to the trial structure question, because I have a feeling it might. But with these cases being medically complex, like med mal cases, how do you make these cases simple for the jury so that they can understand it, even with a lot of complex science and medical terminology?
I'm going to let Ilya take that one because that is so right within her wheelhouse.
It's all preparation. Trial structure is not a shortcut, and it's a good avenue to organize information if that's all you're interested in, and you just want to come to a 2 or 3 hour webinar to learn how the segments are laid out. That's fine. I think you'll get a lot out of it, but we teach that structure really it's like the rabbit hole, and it's a rabbit hole of deep preparation. You used the term, Jason, earlier about resonating, and I love that term because one of the things I liken the law to is an alchemy, right? You take these base metals of tin and iron, and you through the application of heat and pressure, you distill out the essence of the more pure substance, which for the alchemist was gold. Well, what's the gold in a trial? And ultimately, it's the key pieces of evidence that are going to deliver your final result. And so trial structure to me is the process of distilling down. I just finished a structure for a colleague in Arizona, and the room was covered. We had sheets of paper on the wall, halfway down, and some of them 3 and 4 deep, just writing every, the conceivable ways that the defense was attacking his case and planning how we were going to respond and where the gaps in our evidence were and what experts we needed to get so that we could, fill in those gaps. And that kind of work that was, it was 3 days of, laying all of that out. And to be committed at that level and just decide, I'm going to look at the good, the bad, and the ugly of my case, and that way I'll be ready. That's how you get there. And the amazing thing is, at the end, it looks so simple. It's like, duh, how could anybody, people will say, they'll actually say, well, that doesn't sound like a case that needs structure. It's like so obvious. And again, the dog attack case, 17 days. We structured it. The lawyers took it. They focus grouped it. They came back. They're like, nope, focus group still hates it. We wrote and wrote and wrote. They took it out. Focus group still hates it. They like it a little better. And there's no replacement for that. But if you want to give that case the best chance at trial, this is the way.
And it eliminates a lot of the, no case is going to be certain. You just can't get there. But you can certainly eliminate a lot of the uncertainty. And if you plan for and prepare for every way they're coming at you, and you project it before they ever do it, when the jury sees it, they go, we knew that was coming. And the only way they know it's coming is because you're telling them, be prepared for this. And they see it, you see it, and they see it for what it is, which is just an attempt to confuse the issues.
Yeah, very true.
So with you guys, your experience, what do you see that most trial lawyers get wrong about litigating brain injury cases? What's the most
This is all
common
you,
mistake?
Jamie.
Whew. Here's what I think. Here's where trial lawyers go wrong litigating brain injury cases. They think about the end money instead of the investment money. And I've seen it happen more than once. In fact, I'm co-counseling on a case that I'm being brought in July, and I was brought in 3 months before the case was going to be tried. It was already ready and pre-tried before I got in. And I have to start boiling down, why'd you do this? Why'd you do this? Why'd you do this? And the answer comes back consistently. It's because I didn't want to spend the money. And I get it. We all have practices to run. We all have preservation of capital we've got to do. But in a brain injury case, that can't be in the calculus. It's got to be, we're all in. And I, as much as it may keep me up at night to know that my house is mortgaged so that I can be all in, I know that that's the only way to do the medicine. I know that that's the only way to do the biomechanics. I know that if I leave a gap or a crack in the case, it's going to be exploited and everything's going to pour out of it. So, and if you think about the end money, in other words, what the case is going to bring, instead of thinking about the investment today that I've got to do to get it there, you're gonna end up with a bad result.
So true.
Yeah, the investment in these types of cases, that's I've seen it in other aspects. I've seen cases where that investment was not made, whether it was an investment of time or an investment of money on experts, and it doesn't end well typically, unfortunately for the client. And that's really what we're all here for, is to make sure that that client has the best possible outcome after something pretty awful's happened to them. So last couple of questions, I'll let you guys go. I really appreciate your time. This is a bit of a self-serving question given what we do, but in each of your opinions, what are the most difficult issues that you're facing when a case settles these days? Is it dealing with Medicare? Is it the liens? Is it Medicaid? What types of issues are you typically seeing that become really problematic at the end of a case?
I'll give you some very, very recent experience, and it's like last week, last Friday, the Friday before I started trial. It is all of the above. It's big Medicare set aside issues, that it's hard to get predictability soon enough, and it's lien resolution where it's hard to get predictability soon enough, because in brain injury cases particularly, where you don't have the processing to process it, but in every other case as well, what does the client want to know? You walk into mediation, same question, almost with 100% certainty that's going to come at you. How much of this is going to be in my pocket? What's my takeaway? And you can't answer that until you can give some estimates, but good luck giving an estimate to a client, because the range is huge, because oftentimes the lien resolution resolves the case. If you can resolve the liens at this, the case can be settled. But if you resolve them at this, that case is lost, you may as well try it. And if you can't answer the question, how much is in my pocket, or at least get the backstop, like a Medicare set aside ahead of time, to tell the client, you're going to have a very difficult time resolving that case. And if you do resolve it, you're going to have some very difficult liabilities if you're trying to do it yourself. And just like Ilya said, put the best people on the best part of the problem, because it's what they do.
I think the ahead of time piece is really critical. Lately, I've been brought in on more cases, and so there's usually some other effort at mediation right before we get into trial again. And I'm surprised that the lawyers very often don't have final lien amounts, they don't have Medicare amounts, they don't have agreements ahead of time. And it makes it really difficult, because we all know that question's coming. And it's not, I know for myself, there have been times when I've just been in over my head, but as a practice, we should certainly be way better about that than we are.
Yeah, being proactive, particularly on the Medicare front these days, is really important. Anytime I give a presentation on those issues, I talk about this is an area where you may want to be a little bit collaborative with the defense to talk through, okay, well, what happens if we settle this case? My client's a Medicare beneficiary. What are you going to require in the release? What are your clients going to require in terms of reimbursement of Medicare? Do they have any, particular requirements in identifying whether there was a Part C plan, Advantage plan involved? Because, what happens is we will get contacted and they're saying, well, the other side, they've got all these, pages in the release. I don't understand this language, and we review it and it's terrible. And we're saying, hey, you don't really want to sign that. Well, it's kind of late in the game after you've mediated the case, agreed to settle the case, and 30 days later you're haggling over, terms in the release. So I think that proactive part, especially now with, particularly at least in the Medicare world, I think really all these issues, because it does make things go smoother, generally speaking, if you have some collaborative work with the defense once the case resolves about some of the more complex issues that can arise at settlement.
And it changes daily. I mean, how we deal with, Medicare, Medicare Part B, Medicare Part C in front of a jury, today that answer is probably going to be different than after the appellate courts of the Supreme Court answer that question in Florida 6 months from now. So it's you better get somebody who makes it their business to keep it on their radar, because if otherwise you're going to spend a lot of time tracking that radar yourself, and that may not be the best use of your talent.
Yeah, that's very good plug for our tagline, allowing trial lawyers to focus on what they do best. Because I mean, it is an area of expertise unto itself. So if trial lawyers are not working with Synergy, they need to work with somebody that understands these issues. And it's not every case, but there's a lot of cases now that are complex enough where you may need someone to give you a little bit of advice and consulting, even if it's not, complete turning over the resolution of some of these issues. But there definitely are, and it's evolving. And so, like you said, if you're not going to keep tabs on it, you could wind up in a situation where you just don't know exactly what you need to be doing.
And I can't tell you how many seminars I've left where you've spoken, Jason, or somebody else has spoken for the FJA, where I've gone back to my office and said, oh my God, and it's, oh my God, we need to look at this. Because those are the moments they will keep you up at night, just like statutes of limitations will. It's what you don't know may kill you.
And
So.
this will be my shameless plug for Jason, but really, I know for myself, the realization that, the liability shifting, no offense, Jason, but to have somebody else on the hook for, finding that information, it's such a affordable rate, for what you charge for your services. I mean, there's almost I'm hard pressed to come up with a reason why you wouldn't do it. It doesn't seem wise. It does give you that the freedom in your mind to know that somebody is handling that, whose job it is to handle it, who's probably going to do it better than me anyways, and to not have the exposure on the back end it's a huge relief.
Jason, I've got a question for you if you know the answer to it. I know that lien resolution is looked at by the Florida Bar as part of the package that we deliver as a trial lawyer when we sign the contract. Are firms dealing with that up front and saying, hey, if you sign with my law firm and we have to do lien resolution as part of the package, we're going to use so-and-so and here's going to be the rate. But I'm letting you know that up front. Are you seeing that in the initial client contract?
Yeah, many firms are putting it into their contracts now. And, Florida is a little unique because we did have this proposed rule that went to the Florida Supreme Court, and the Florida Supreme Court, had some stuff in dicta, which really did not, if you boil it down, and we don't have time to do that, but it really didn't apply outside of cases that are like cases that I handle at DOA for Florida Medicaid, because I've got a law practice that's separate from Synergy. Those are the types of cases that really that was focused on, where another lawyer is brought in. But there are many firms that are putting that into their contracts because they know that there is that potential at the end of the case, and clients should have that, informed consent provided to them prior to it even getting to the point of, hey, this is a complex case where, we're going to refer this out to a lien resolution group to make sure that we get you the best, possible net proceeds, because, experts are what is needed to get that.
Well, if you have some examples of how that's being done, I'd love to see it,
Yeah,
because
absolutely.
I think that's a wise idea.
Yeah. Anyone listening to the podcast, if you want a sample of that, I certainly can provide it. All right, guys. Last question. I'll let you go. Since this is the Trial Lawyer Review podcast, my final question always is what is your view as a trial lawyer? And you can talk about whatever you want. So we'll let ladies go first.
What's interesting that you put it that way. I was a very fortunate young lawyer that I had some stellar mentors, and continue to have stellar mentors. Jamie among them, colleagues and mentors. But what I lacked, I felt 20 years ago when I started in personal injury, was a lot of access to women trial lawyers. And while I see that that's changing, it's still pretty slow. And so part of my view is not only changing trial practice via trial structure, but also making a better place for women. I think a lot of the instruction I got as a young lawyer worked for my male colleagues and not so well for me. And I have learned, some through trial and error, some through trial structure, what does work for me and what seems to work better as a woman litigator. And so my view is to make the path of being a successful trial lawyer better and easier for those who come after me, including my fellow women trial lawyers.
I love that. My last guest on the podcast, Kate Conway, talked about those issues, and I've had a lot of other women trial lawyers on the podcast who have talked about those issues, and I think it's great to continue to get that dialogue out there. Thanks for sharing that. All right, Jamie.
Well, I will tell you, my biggest view is you better be prepared to listen to the voices that aren't you. And what do I mean by that is I have a ton of blind spots, and I know it. And my strength is I know it. So I spend a lot of time with some really, really, really wise people out there who give me access, and in return I give them access, and we talk about it, and they're brutally honest with me and say, Jamie, you're missing this. You really ought to look at this, and I tell them the same thing. But having that sort of collaboration makes me so much better lawyer, because without it, without the friends and the relationships and the ability to pick up the phone and say, I got this problem, can you help me? And then come back and say, I can not only help you, but here's where you're missing it, here's where you're missing it. Listen to the voices that aren't your own, because that is a strength.
That's really good overall advice in business and personal. I absolutely love that, because it's something that I've been very intent on the last 5-6 years, is making sure I'm as good of a leader and as a employer and a person. And really the way you do that is by becoming aware of yourself and your blind spots. And so that's great advice. All right. So I know that you guys talked a lot about co-counseling cases, and I'm sure there are instances where other lawyers refer cases to you. So I wanted to give you both the opportunity to give out your contact information here on the podcast. We'll include it in the show notes, but I wanted each of you to be able to give that out. So if somebody's got a question about trial structure or all the stuff we talked about brain injury cases, or wants to work with you, what's the best way to get in touch with you? And again, I'll let ladies go first.
Well, the trial structure website is probably the best place to start for information. I will caution, we get a lot of requests for written materials, and we really don't publish a lot of information for obvious reasons. We don't want it misused by the defense bar. So if you have questions about trial structure, what it is, what the process is. That's the best starting point, and all of the contact information for us is there. My website, or excuse me, my email address through Trial Structure is Ilya, my first name, ILYA, @trialstructure.com. But there's a number of other addresses, the other instructors, our info, and then, of course, our office manager, Katanya, and the executive director, Brad. All those are people that you can start with. So if you have questions about Trial Structure, that's the best place to start. You can also reach me there personally, too. So any emails directed to me, I get them all. So that's really the only address you need to know.
Same place, same answer with one caveat. You can email me at jamie@holland.law, and it's literally JAMIE, Holland@holland.law. So it's that easy. But if you send me an email, because of the 1,000 I get a day, if you text me at 904-910-1080 and say, hey, Jamie, I just sent you an email. Tell me what you think. You're much more likely to get a response. Because I hate to say it, but if you want to communicate with me, it takes the belts and suspenders approach. I wish it were different.
Yeah, and
but
I don't have any issue with people using my cell either. My number is 602-628-0190, and I'm always open to text and calls. My cell phone's always with me, unless I'm in trial or something. So good way to reach me too.
Well, thank you to you both for joining me today on Trial Lawyer Review, and we will see all of you on the next episode. Thanks for tuning in.
Thanks, Jason.
Thanks, Jason.
Thanks for tuning in to Trial Lawyer Review. You can find more at triallawyerreview.com and look for more episodes and more content coming in the future.